Good morning. Welcome again to the agenda meeting of the Minnesota Public Utilities Commission. We are continuing our agenda meeting that began on Friday. Today, the Commission will hear arguments from the official parties to the proceedings. The agenda item has already been introduced. To remind folks, we will first consider the adequacy of the EIS and then move on to the Certificate of Need and route permit should the EIS be determined adequate. I thank the public for their interest in our proceedings and ask that everyone in the room remain seated. If you need to leave to use the facilities, please take a pass from a PUC staff at the back doorway. Again, our proceedings are broadcast on the PUC's website as well as the Minnesota Senate website and on monitors in the overflow room next door. The question before us now is whether to accept the revision of the final EIS as remanded to the Commission by the Minnesota Court of Appeals. As parties know, the EIS was determined not adequate on one issue by the Minnesota Court of Appeals. I will read the decision statement from the Court of Appeals in their June 3rd, 2019 decision. The FEIS properly defined the purpose of the project, sufficiently identified the alternatives, including a no-action alternative, and utilized an appropriate methodology to analyze potential impacts from oil spills. The FEIS adequacy analyzed potential impacts of greenhouse gas emissions, potential impacts on historic and cultural resources, the relative impacts of alternative routes, and cumulative potential effects. However, the Commission acted in a manner unsupported by substantial evidence and arbitrary and capricious when it determined the FEIS adequate despite its failure to address the issue raised during scoping and in public comments on the DEIS of how an oil spill from Enbridge's Line 3 project would impact Lake Superior and its watershed. Accordingly, we reverse the Commission's adequacy decision and remand for further proceedings consistent with this decision. So the question again before the Commission now is whether the second revised EIS is adequate. We will take oral arguments on this question, move to questions from commissioners, and then deliberate on the adequacy. The parties who are here today to comment on the second revised EIS, please state your name for the record and the organization you represent. We'll begin on my far right with you, Mr. Benoit. And then we'll use that handheld microphone. If the parties could please pass it down. And then for opening comments, if the parties could each come up to the dais for their 5-minute opening statements. Mr. Benoit, good morning. Please state your name for the record.
Good morning, Madam Chair, Commissioners. My name is Benjamin Benoit. I'm here representing the Leech Lake Band of Ojibwe.
Morning, Chair, Commissioners. My name is Joe Plummer. I represent the Red Lake Band of Chippewa.
Good morning. David Zoll, and I represent the Mille Lacs Band of Ojibwe.
Sarah Van Norman here on behalf of the Fond du Lac Band of Lake Superior, Chippewa.
Good morning. Mike Ahern on behalf of the Shippers Group.
Good morning. Kevin Pranis on behalf of Liona, Minnesota, and North Dakota.
Good morning, Madam Chair, Commissioners. Christy Brusman and Eric Swanson here on behalf of Enbridge Energy.
Good morning, Commissioners. My name is Paul Blackburn. I represent Honor the Earth and the Sierra Club, and that raises a point of order, if I could just ask that, whether, and also Winona LeDuc will be here representing Honor the Earth. And in terms of the 5 minutes, will each Sierra Club and Honor the Earth have 5 minutes, or will they be combined because I represent both of them? Just a question. Thank you. Good morning.
Scott Strain, Environmental Law and Policy Center, on behalf of Friends of the Headwaters.
Good morning. I'm Brent Mercia, one of the 13 youth climate interveners representing ourselves.
Good morning, Madam Chair, Commissioners. Louise Miltich with the Minnesota Department of Commerce, Energy Environmental Review and Analysis. Good morning, Chair Sieben, Commissioners. Catherine Hinderly on behalf of the Division of Energy Resources of the Department of Commerce, or DER, and DER defers to EERA on all issues with the EIS and will not have an opening statement.
Good morning, Anna Friedlander on behalf of the United Association.
Mr. Blackburn, to answer your question, I think it's fine if you each take 5 minutes since you are both parties to the proceedings. So we'll start with Ms. Miltich, please. If you could please come to the front and make your opening statements. And then following Ms. Miltich, we'll start on my far right, move down, and then skip Enbridge and end with Enbridge for this portion of the proceeding.
Madam Chair, Commissioners, I appreciate the chance to give an opening statement today on behalf of EERA. I want to start by talking a little bit about the scope of the decision in front of you today. The adequacy question in front of you is quite narrow and specific at this point in time. All of the other issues are out. This is the final in a series of opportunities that you've had to consider a similar range of concerns about the adequacy. The arguments before you today, in many cases, have been vetted multiple times. The arguments before you today have also been vetted in front of the Court of Appeals. So there is just one remaining issue, and it's about fixing a very specific gap between the original EIS and what was in the scoping document. The only argument that remains unresolved is the one around 4410, 2800 subpart 4A, specifically addressing the impact of a spill into the Lake Superior watershed to bring the EIS in line with that language that was in the FSDD, the final scoping decision document. That is the only adequacy issue that's in question today. It's not the climate change assessment or the health impact assessment. It's not even the modeling methodology. Those things were spelled out in the scoping document. You've heard them multiple times, and the Court of Appeals heard them. The question before you on adequacy today is whether additional modeling at the Otter Creek site, combined with the existing analysis of the potential impact of spills that was in the EIS, is sufficient to address the court's ruling and bring the FEIS in line with that language that was in the FSDD. So the question for the day is whether the addition of the Little Otter Creek site, with the addition of that Otter Creek site, does the EIS adequately address the FSDD language indicating that the EIS would consider the impacts of a spill into the Lake Superior watershed? And it does. Let's begin with how the potential impacts of an accidental release across the entire project area, across all the watersheds, crossed by any route alternative, all the way from the Canadian border to Superior, Wisconsin, were evaluated in the original EIS. That's a good baseline to start from. It's critical context for what you're going to be looking at today. We looked at the probability and the likely size of an accidental release for pipelines, rail, and tanker trucks across that entire span. We provided information on spill risk and exposure of vulnerable resources all the way from the Canadian border to Superior, Wisconsin. And then we provided information on representative modeling sites. They were modeling vignettes applicable to conditions at water crossings across the entire project area, all of the watersheds. Finally, we considered but did not select a representative modeling location within the Lake Superior watershed. That was all part of the original EIS that was in front of you. The only thing we did not do was select any of those sites within the Lake Superior watershed. That it was the one and only thing we have worked to correct to bring the EIS in line with the FSDD. And I'm here before you today to say that the Little Otter Creek closes any real or perceived gap between what was in that original EIS and the language in the FSDD. We chose the Little Otter Creek site because we were trying to address the original purpose of the modeling. The objective with the spill modeling portion of the assessment of potential impacts of accidental release was to have vignettes that spanned the range of conditions across the project area. So we chose locations that we felt added value to that overall picture of how oil might behave in the kinds of environments across the project area. We came back to that original purpose in the selection of the Otter Creek site. It was chosen because in addition to the 7 sites we already had, we felt it gave the best value in terms of enhancing our understanding of how oil would behave in the kinds of environments crossed by the project. The outcomes of this 8th site, the outcomes of the modeling, reinforce what we learned from the original 7 sites. It showed us the serious implications of a full-bore rupture allowed to proceed over a 24-hour time window without any cleanup efforts. It also showed us that a full-bore release fills a small stream with oil. Transport through turbulent waters results in entrained oil, sinking oil, and after 24 hours, oil still remains at the surface of the water body. That is what you have before you today, and it closes the gap between what was in the original EIS and what was in the FSDD. I appreciate the chance to offer initial statements, and I will be happy to answer questions. Thank you.
First, we'll continue with the parties with opening statements. So, Mr. Benoit, if you'd like to come forward, please.
Thanks for the opportunity to give an opening statement. Good morning. My name's Benjamin Benoit. I'm the environmental director for the Leech Lake Band of Ojibwe. Also here today is Jason Decker, our tribal attorney. We're both tribal citizens, and we're here to ensure that Leech Lake's position is clear as Minnesota enters this decision-making process. Much of the focus of the recent comments on the FEIS have been about the potential impacts of an oil spill from the new Line 3 pipeline within the Lake Superior watershed. That's appropriate. However, let's not focus on one tree so much that we lose sight of the entire forest. I want to remind the Commission of the facts already in your record regarding the potential impacts of a spill from existing Line 3 on the water and other resources we depend on within the Leech Lake Reservation. As we have testified previously, 10% of Minnesota's fresh water lies within the boundaries of the Leech Lake Reservation. As Levi Brown testified, existing Line 3 goes right through the heart of what we refer to as the Water Triangle, first crossing the Mississippi River at Cass Lake, which is the 7th largest lake in Minnesota, then passing by Leech Lake, which is the 3rd largest lake in Minnesota, and then Lake Winnebagosh, which is the 4th largest lake in Minnesota. Then it exits the reservation. A spill or release on existing Line 3 would endanger the very cultural and socioeconomic well-being of the members of the Leech Lake Band. The existing pipeline runs over the heart of wild rice country when it crosses through the Leech Lake Reservation. The damage to the environment, if a significant spill or release occurred within the current Line 3 on the Leech Lake Reservation, would be nothing short of catastrophic for Leech Lake citizens and their way of life. As the Commission considers these decisions, Leech Lake urges the Commission to recall the discussions in Chapter 10 of the FEIS that clearly states the risk of a release from existing Line 3, a pipeline with known integrity issues. In the next few days, the Commission must make important decisions for Minnesota. For the band, nothing has changed, and we remain steadfast in our decision of no. We will not approve a pipeline across the reservation, and we still think that existing Line 3 should be removed from service. We are grateful the Commission understands that the Leech Lake Band of Ojibwe has the right and responsibility to manage and protect lands and resources that fall under our jurisdiction. It was clear the Commissioners respect the band's sovereignty as a decision maker when in 2018 commissioners listened to the band say no and removed RA 07 and RA 08 from consideration. In regards to the FEIS, these routes were never feasible alternatives, and we maintain that the FEIS oversteps by characterizing them as anything but impossible. Thanks.
Thank you. Good morning, Mr. Plummer.
Morning, Madam Chair, Commissioners. You know, one thing I wanted to say, just by way of history here, with the EIS, when we first started appearing before the Commission back in 2014, when the Sandpiper was being planned, when this same corridor that was being promoted by Enbridge back in 2014, the Commission and the administrative law judge decided that an EIS, an environmental impact statement, was not necessary, that it was not, despite the ultra-hazardous activity of transporting tar sands through a brand new corridor. The Commission at that time decided that an EIS was not necessary. The little simple environmental impact comparison sheet was good enough. Well, we remember what happened following that. That decision was appealed by a couple of the parties that are here today. And the Court of Appeals sent instructions back to the Public Utilities Commission and said, it's a no-brainer. This is absolutely a situation where an EIS is essential. And what did the applicant do at that time? The applicant stepped away. The applicant did not want to wait and go through the responsible steps of an environmental impact statement. Instead, they went and bought into the DAPL, the Dakota Access Pipeline over in North Dakota, a very controversial pipeline. Well, that corridor that the applicant wanted at that time for the Sandpiper is the exact same one that was previously approved by this Commission. And while all of the steps have wormed their way through to today, and the department has identified a single issue. I understand it is a single issue, but I think it's a little more complex than whether or not the spill modeling that was done for this Little Otter Creek location is good enough. And what I mean by that is that at that location of Little Otter Creek, it's not just Line 3 that goes through. The Enbridge main line goes through that location. And the Enbridge main line at that point is 5 separate pipelines. So if there were a catastrophic break, it wouldn't only impact just Line 3, it would impact all of them. And there's all kinds of causes that could occur. Who knows what's going on around the world these days? Another world power not friendly to the United States could drop a bomb on that and make a clean break of all 5 of the Enbridge main line pipes, and they would all go spilling into the Lake Superior watershed. The reason I'm saying this is that the department thought that it was adequate, to analyze the spill of just the one pipeline, but not all the rest of them. Another thing that I think, is important is I appreciate the evolution of the Commission in being able to properly apply environmental laws. As you've heard me argue throughout all of these proceedings, our interest from the tribal perspective is to keep the environment, the water, the animals, the plants clean, because we have reserved off-reservation gathering rights in these areas, and for those rights to mean anything, we need to be able to keep those areas as pure as possible. By introducing things, like these pipelines, it jeopardizes it. It saddles us with the risk. And I don't believe that it's a reasonable risk. That's all my opening statement. Thanks, Chair, Commissioners.
Good morning, Madam Chair and Commissioners. Again, David Zoll on behalf of the Mille Lacs Band of Ojibwe. Notwithstanding the Court of Appeals decision, the revised FEIS continues to have some key shortcomings that I just want to remind the Commission of. First, it fails to provide a full analysis of the comparative impacts of the various route alternatives that were considered. It also includes a thoroughly inadequate analysis of the potential impacts on cultural resources. The analysis that is included is insufficient to allow a meaningful comparison of the route alternatives. I'm cognizant of the Court of Appeals decision, but I caution this Commission that adequate is a low bar. The analysis of the comparative impacts and the analysis of impacts on cultural resources in particular can be better and should be better, particularly when it's informing a decision to open a new pipeline corridor crossing a significant portion of northern Minnesota in areas over which the tribes continue to exercise treaty rights and which are of sacred importance to my client and to the other tribes that are represented here. Now, I'll turn to the narrow question as framed by the Department of Commerce, which addresses the adequacy of the revisions in the second revised FEIS. And I urge the Commission to consider carefully the comments that you'll hear from other parties regarding the location of the spill modeling. If we want to know the true risk to Lake Superior and its watershed, that analysis needs to be conducted where there is the greatest potential to impact Lake Superior and the St. Louis River estuary, regardless of whether that location is in Minnesota or in Wisconsin. It's no defense to say that the little Pokegama and the Pokegama rivers are in Wisconsin. That's where the analysis needs to be conducted. Approval of the Line 3 replacement project will increase the volume of oil being sent through the entire pipeline, including the portion of the pipeline located in Wisconsin. And that increased volume of oil will increase the amount of a spill at a location. And quite simply, if we want to know the full potential impact of a spill and its effect on Lake Superior and its watershed, the analysis needs to be conducted at the nearest point upstream from those resources. And the decision that's made, if a certificate of need is granted and if a route permit is approved, will increase the amount of oil that could be spilled in the event of a catastrophic failure in Wisconsin, and that impact will be acutely felt in the downstream waters in Minnesota. Thank you.
Thank you, Mr. Zoll. Good morning.
Morning, Chair, Commissioners. Sarah Van Norman on behalf of the Fond du Lac Band. A quick note before we begin. I will note you probably saw some empty chairs here on Friday. It was a quarterly meeting of the Minnesota Chippewa Tribes Tribal Executive Committee, and that also meant that some other voices probably weren't here as well. Regarding the specific aspect of revised EIS adequacy, the band provided input on this to the department and to the company. The Lake Superior watershed is, of course, of inestimable importance to the band. It includes a large portion of the band's reservation and off-reservation ceded territories. But the band needs some certainty here. The band has particularly unique impacts due to the fact that new Line 3 will follow the existing Enbridge main line along RSA 22, as the Commission is well aware. And we think it's time for certainty on the schedule and issuance of this revised EIS. Thank you.
Good morning. Good morning, Commissioners. My name is Mike Ahern. I'm here on behalf of a group of customers of the Enbridge Main Line, the shippers group. We're here testifying to the continued need of the Line 3 replacement. As some of you may recall, the shippers generally did not participate in the environmental review portion of this docket, leaving that to others. But due to the comments that came in regarding this final revision, suggesting that with the absence or the lapse of time, there was no longer a need. We felt it necessary to at least inform you that we believe there still is a need. Our message is very simple. The Commission should reaffirm the final environmental impact statement. Your solid findings underlying the Commission's original Certificate of Need order remain unchanged. The only material change in circumstances since the original Certificate of Need has been the passage of time. With that, we'll stand for questions.
Thank you.
Thank you, Chair, Commissioners, for the opportunity to address this topic for behalf of Lyon, Minnesota, North Dakota, and our 12,000 members who hope to build this pipeline and make the Minnesota safer soon. The question of whether the EIS is adequate as a matter of law, I think the answer is clearly yes. The Court of Appeals has rendered its judgment and provided a clear and simple roadmap applying the spill modeling that the court found to be sufficient to a representative site on the Lake Superior watershed. The appeals court previously determined the EIS properly identified and evaluated reasonable alternatives, and the court considered and rejected other arguments against the adequacy of the FEIS, which continue to be recycled by opponents of the project, reminding us that the EIS is meant to be a, quote, analytical rather than encyclopedic document. But the next question is, does the EIS meet the policy goal of the environmental review process, or is this a case where the law falls short of the intended policy? And the answer is the EIS clearly meets the goal. The FEIS contains environmental facts that, in the words of the court, help the Commission to, quote, uncover the data necessary to make an informed environmental decision. That's important. It's not all the data that could possibly be obtained. It's the data necessary to make an informed decision between the alternatives which the court has upheld. So, for example, thanks to the EIS, we know that newer pipelines are much less likely to spill than older pipelines. We know that oil is 50 times more likely to be spilled if it travels by rail. We know that the construction project like Line 3 is associated with significant economic benefits. And we know that the environmental and tribal resources along existing pipeline corridor are arguably just as valuable even after 50 years of coexistence with pipelines than the resources along the applicant's preferred route. All of those help to make a decision between the alternatives. Now, we also know that that crude oil spills have the potential for environmental and tribal resource harm, but that those spill risks are a feature of both the proposal and all of the available alternatives, especially the no-action alternative. We also know that carbon emissions and social cost estimates based on the consumption of the oil from Line 3 are significant, but those are also not unique to the project, but characterize all of the alternatives and therefore don't help arrive at a decision. Now, opponents would have you believe that somewhere there's an environmental fact that would turn this record on its head if only the Commission would take the time to find it. But they've given the Commission no reason whatsoever to believe that's true. A lot of rocks have been turned over. There's no evidence that turning over more rocks will finally find a fact that will turn this record on its head. So the question is whether we should spend another year or two studying why spills are bad, or should we act now to reduce the likelihood of a spill? Should we spend another 5 years studying the impact of carbon that will be emitted whether or not Line 3 is replaced, or should we replace Line 3 and get on with trying to reduce the actual sources of carbon? Remembering how we got here in the first place, opponents to the project wanted an environmental impact statement process, and they wanted it produced before the filing of testimony in the contested case process. They got that. They got both of those things. Not at our preference, but that's what happened. All the facts were supposed to be on the table. Those have been delivered. At this stage, it's clear the purpose of requesting additional environmental review is not to inform the Commission's decision, because the information sought would not affect the underlying rationale for the Commission's prior decision on this project. The purpose is indefinite delay, which would effectively implement the no action alternative. So if we consider what are the costs of following along this route, we think that a decision not to deem the FEIS adequate would have implications for the climate, but not the implications that some of the opponents think. The EIS process should not be used as a weapon to grind permitting to a halt. Those who wish to employ that process to block this pipeline out of climate concerns should be careful what they wish for. The statutes that establish the EIS process are not specific to fossil fuel infrastructure. They apply equally to transmission lines and other large infrastructure that will be essential to climate progress. It's difficult to see how climate change can be halted without aggressive, rapid deployment of energy and other infrastructure, including transmission. But as with pipelines, not everyone along transmission corridors agrees that they are in the public interest. If we actually want to solve the problem in climate, it's important to maintain the integrity of the EIS process and its ability to come to a reasonable conclusion following the law. That's the only way we actually make progress. And I urge the Commission to find the EIS adequate. Thank you.
Thank you, Mr. Prentice. Mr. Bebo, welcome. If you would like to give 5 minutes of opening comments on the EIS now, you're welcome to, or you can do it after a few more people, whatever you'd prefer. So next, Honor the Earth, please. Or, Mr. Blackburn, I'm sorry, will you identify whether now you're representing the Sierra Club or Honor the Earth?
Again, good morning, Chair Stephen and Commissioners. In this 5-minute segment, I'll be representing Sierra Club, and at the same time, I also wrote the briefs and did the work of the Court of Appeals on this particular issue before you today, so I'm going to speak from both my knowledge bases, if that's acceptable. To start, there is no denying that a spill from Line 3 could affect Lake Superior, the harbor, and the estuary. There's been a lot of misrepresentation in the press and other places that it won't. That's false. It's demonstrably false by all of the evidence in the record. First, the revised EIS itself says that oil can go somewhere between 8 and 24 miles in the St. Louis River, and we have other places where they talk about the distances. The revised EIS fails to say how far the Wisconsin spill sites are from the lake and the harbor and the estuary, but they're between about 5 miles to the estuary and about 15 miles to the lake, not including the Nemadji River site, which wasn't evaluated by the EIS at all, where it's more like 5 miles to the Lake Superior. The revised EIS also admits that there are closer downstream locations. The Wisconsin EIS says that a spill to Lake Superior is possible. The Line 6B spill, which is in the record, that went 36 miles. The U.S., and if you don't believe that, the U.S. Coast Guard and Enbridge, U.S. Coast Guard's Western Lake Superior Area Contingency Plan, that's its contingency spill response plan, says that the Coast Guard is planning for a spill from the Enbridge terminal or the pipelines into Lake Superior. And finally, there was actually a spill from Line 4, could have been associated with Line 4, according to federal records. Line 4 parallels Line 3 into the Nemadji River of 4,500 barrels of crude oil in 2003. Those are all on the record. Those are all facts. There's no denying. So all we really said was, well, if you look at the map, this pipeline goes pretty close to these critical resources. These are the commercially most important waters in Minnesota. It goes very close to them. So why didn't the EIS evaluate a spill into these waters? I mean, it's a pretty common sense question. You know, these are pretty important waters, and the Line 3 goes close to them, and yet the EIS does not discuss the spill's impact into these waters. And the answer, I think, is probably because the Department of Commerce, so a couple things. The Department of Commerce only wanted to evaluate spill sites in Minnesota. But that was before the NTEC decision, that said that a project's impacts and out-of-state parts of a project need to be evaluated. But also, the Department of Commerce has a very academic approach to this. They said that they're concerned about how oil behaves. This isn't about how oil behaves. This is an environmental impact statement. It's about environmental impacts. It isn't about picking spill sites and then saying, oh, academically, this is really interesting how the oil behaves here. This is about potential impacts to critical resources in Minnesota. And the Department of Commerce's perspective on this is simply wrong. And the law is also wrong. And it's really unfortunate that you're being backed into this corner once again in terms of making a decision. The Department of Commerce could have asked Honor the Earth or the other parties to talk about how to respond to the Court of Appeals decision. They certainly worked with Enbridge's consultant on that, maybe talk to Enbridge, I'm not sure. But they didn't talk to us and say, what would be necessary for us to comply with your interpretation of the Court of Appeals decision, the issue that Honor the Earth brought. But they didn't bother to talk to us. I think that was a big mistake on their part. Because now, you're in the position of, rather than just simply doing the common sense thing and saying, these resources are at risk, and we need to figure out what would happen if they were damaged by a spill. But you don't have that before you. And it wouldn't have been that hard for them to do another analysis, right? They could have just done it. Why couldn't they? I mean, it maybe cost a little bit more money, but they could have. But they didn't. So now you're going to be in a position where we're probably going to end back in court again if you don't go ahead and fix this. Because we asked very expressly the Court of Appeals for an analysis of the impact of the estuary, the harbor, and the lake. And the Court of Appeals shorthanded that by shortening it to the Lake Superior watershed, which is thousands of square miles. And yet, here we are. And it's something we've asked for years. And we think it's reasonable. And we think the Commission should be aware of the impacts to these critical waters. And you aren't. The EIS doesn't tell you that. The Wisconsin EIS doesn't have any analysis of Minnesota resources because, guess what? It's from Wisconsin. Their jurisdictional limits do not include evaluating Minnesota resources. We argued all this stuff in NTEC. And it's unfortunate that Department of Commerce didn't simply sit down and ask us, what do you want? How are we going to fix this? But you didn't. And that's unfortunate, and it's put all the commissioners here in a difficult situation because we're going to be running this. We want that analysis. And if you don't give it to us, we're going to keep pushing every way we can. We think those waters are that important. Thank you.
Thank you. Mr. Strand.
Madam Chair, members of the Commission, now that the police have left my field of vision, I'll go ahead and start with my statement. Again, I'm Scott Strand. I'm with the Environmental Law and Policy Center. I'm here on behalf of Friends of the Headwaters. I've also been advised that the DIBDALs are willing to cede their time to me, so I might go a little bit over the 5 minutes, but I'm going to try to keep it as briefly as I can, if that's okay with the Commission.
The deer dolls?
Yeah. All right. What I want to focus on today is not so much the factual issues that are presented by the various comments that have been made on the second revised EIS. I certainly urge the Commission to read those comments directly. I don't think they've been adequately summarized in the briefing papers. I think it's really important to look at the actual comments and the attachments and the information that's been provided. So please do that. But consider some of the legal issues. You were told at the beginning of this hearing that this is a very narrow issue, that the appropriate approach for the Public Utilities Commission is to tell the Court of Appeals that its ruling was very narrow and that you're going to respond in the narrowest way that you can. I'm not so sure that's the best approach to take. As Mr. Blackburn just said, the argument before the court was that there was a large gap in the environmental impact statement, that we really didn't have the information we needed to assess the impact on all of the features he described, the Lake Superior watershed generally, the estuary, eventually the lake. It was not a narrow consideration that if they could just get fate modeling analysis at some water crossing somewhere near the Lake Superior watershed, that we'd be done. What the court wanted to hear from this process was a genuine assessment as to what kind of a threat a big spill on this pipeline would pose. And you don't have to look very hard. You look at the maps and you can see where the logical places would go. They would be the crossings that are much closer to the lake, closer to the estuary, that happen to be on the Wisconsin side. Now, there wasn't an analysis in the second revised EIS about, based on the science, about why the Little Otter Creek crossing would be better than those. It was a legal judgment. A legal determination was made that it would be inappropriate for this commission to direct that those crossings be evaluated. One, because we don't have jurisdiction to look at Wisconsin. Well, we know that the Court of Appeals has already said that that's not the case. The rule in Minnesota now is that if there's an out-of-state facility that this commission has regulatory authority over that might have an environmental impact that would affect Minnesota, you're not only do you have the option of evaluating that facility, you have the obligation to evaluate that facility under the Minnesota Environmental Policy Act. Same situation here. I think telling the court that their ruling in the Line 3 case was very narrow, and then telling the court we're not going to pay any attention to the Minnesota Power ruling and its judgment about what this commission has jurisdiction to do, I think really runs the risk of this process just continuing longer. But there were more legal determinations. The second determination was that because Line 3 in Wisconsin is already built, that somehow that makes it moot. Well, that's not the case either. It's up to this commission to decide whether or not 760,000 barrels a day, or maybe ultimately 910,000 barrels per day, are going to go through Line 3 in Wisconsin. The fact that it's built doesn't change that basic fact. That's what creates the risk to the lake. That's what creates the risk to the estuary. That's what creates the risk to the overall watershed. It's not the construction of the pipe, it's the fact that all of this oil will run through that pipe. And that's up to this commission to decide. So it's not moot. The final legal argument that was made in the second revised EIS is that somehow there is an obligation on the part of the commission to defer to the environmental review that was done by the Wisconsin DNR. There was an environmental review done, and maybe somebody assumed that that environmental review over on the Wisconsin side assessed the spill impacts for Line 3 into the Lake Superior watershed. Even the briefing papers tell you that the Wisconsin environmental review must have looked at the spill impacts into the Lake Superior watershed. But the fact is, that's not true. They didn't do that. And it isn't a qualitative assessment. They said they didn't do that in so many words. They made it very clear in the environmental review document that they prepared that they were not doing a spill impact into the Lake Superior watershed. They hoped that maybe the University of Minnesota Duluth might do something like that someday. They hoped that the Department of Commerce in Minnesota would do a spill impact like that someday, but they made it very clear that they were not going to do it. They didn't do it, and so this notion that somehow you have an obligation to defer to what they didn't do, I think is a legal error as well. So again, why was Little Otter Creek picked? Because it was the furthest east within the Minnesota boundary. Not that it was scientifically representative, it was the furthest east that was still within Minnesota. If you look at the other crossings that make a lot more sense to evaluate the genuine risk to the watershed, you have to look at those other water crossings. The legal arguments for not doing that just don't hold water. I think the commission knows that. I think you understand the risk of continuing with a process that makes that kind of legal determination, So I urge you to reconsider that. Direct the environmental review group to look at those alternative crossings. We also raised the other legal question that I want to address with respect to the Lake Superior issue is this notion that somehow questions like whether or not the 13-minute assumption that any kind of a spill would be detected and immediately the pipe would be shut off within 13 minutes, or that a spill would essentially stop moving after 24 hours. That's not an issue that the court addressed very directly. I think it's just basic common sense, and must be at least a dozen of the more substantive comments that were presented to you, that those are over-optimistic assumptions. The relevant law, again, the EPA rules on what's required for risk management plans say that you can't assume that active technology to manage it is going to work. You can use passive things like ditches and walls and barriers like that, but not the active technology. PHMSA, the Pipeline Hazardous and Materials Safety Administration, tells us that you look at past records of spills, which of course in Enbridge's case include the 17 hours it took for them to discover what was happening in Kalamazoo and start to respond to it. Our friends over in Michigan, who did a I think, very thorough assessment of the potential spill impact of if a spill were to happen in the Straits of Mackinac with Line 5. They used an estimate of 2 hours. They thought that that was a much better, more accurate reflection of how long it would take for a spill to be discovered and for the pipe to be stopped. They recognized, as the agencies have for years, that it's rarely the technology that finds the spill. It's usually reports from people who are on the ground. I think it's about 19% maybe are detected by all of the computer technology, but most of them are detected by people on the ground. So a 2-hour assumption is what they used. In terms of how long the spill would continue to travel, they went through a number of scenarios, from a few hours up to as long as 60 days to create an assessment as to how far the oil would travel. That's a reasonable thing to do. The Court of Appeals didn't say, don't do that. Don't consider reasonable assumptions. Don't follow the models that are set out in the federal law. They didn't address the issue at all. I urge you to address that issue. And I think if you send this back for a review of alternative sites, you ought to also direct that those assumptions have to be changed. And I would urge an assumption of at least a 2-hour time frame between the beginning of the spill and the time it's detected and the pipe is shut down, and then a range of possible alternatives with respect to how far the oil could travel. The Michigan model, I think, is a very solid one. I urge you to consider it. Take a look at those documents, and I think you'll find a roadmap that will let you address that issue. I also want to address the basic legal question again about whether or not you were...
Mr. Strand, you're getting pretty long into the Deerdal's time as well, so if you could
let me
wrap it up quickly.
I'll wrap this legal issue up very, very quickly. And that's the notion that you have no obligation to consider new evidence and change circumstances since the first EIS was done. I think that's what you were advised by the Department of Commerce. I think that's wrong. Once the commission gets jurisdiction back, which often happens, a typical case is like this one where it comes back from appeal, you have an ongoing responsibility to determine whether or not there's new information, change circumstances that are significant, that might affect the outcome of the environmental review process. That's an ongoing responsibility. You have decided deliberately, apparently, not to do that, and I think, again, that creates the risk of a decision here being legal error. So I'll leave that discussion here, and I'll stand for questions.
Thank you, Mr. Strand. Mr. Bibo, would you like to go now? Mr. Bebo, thank you for coming. If you could please state your name and the organization you represent, and we were looking for about 5 minutes of opening comments on the second revised FEIS.
I was notified that Northern Water Alliance would like to cede 5 minutes to me as well.
Okay.
And I may have an interest in sharing that. I just want to see where we get to.
Can you speak a little closer to the microphone and again state your name, please?
My name is Frank Bebo. I represent the White Earth Band of Chippewa, or Ojibwe, or Anishinaabe, or however you understand us to be. Currently, we're called the White Earth Band of Ojibwe.
If you maybe move the microphone a little bit higher, I can hear you, but can the audience hear okay? They're shaking their heads no, so a little closer to the microphone, please.
We'll see if this works better. I'll just lean into it since the microphone seems a little short for me. Again, my name is Frank Bebo. I represent the White Earth Band of Ojibwe. We're also called the Chippewa, and we call ourselves the Anishinaabe. When the United States was first forming up, we had treaties with the United States as far back for our territories for 1825 and 1826. And what those treaties talk about is our right to the territory, to hunt, fish, gather, and those same concepts. And they were reaffirmed in the Mille Lacs decision in 1999. And what all the resources are that we rely upon as a part of those treaties, number one is wild rice. And wild rice is disappearing in a lot of places. And it's going to be vulnerable to all of these kinds of oil spills. It's these activities that threaten all of the wildlife and everything else here. So when you look at things in a shorter fashion, a lesser fashion, you try to determine what's adequate. Adequate isn't really protection. And adequate needs to be looked at in a way, as was discussed recently here, that we should look at the whole EIS and see if really that measures up to the certificate of need and whether or not what's going on is necessary. Because part of what was also discussed was the fact that there haven't really been any oil leaks in the last 10 years on Line 3 because of how it's being operated. Another fact about Enbridge that hasn't really been discussed here is they have a parallel pipeline already in place. That's 20-inch pipeline that they're looking to reverse and pump more oil as well. So the pieces are already here. The safety that we're maybe going to have is already in place because Line 3 is running with less. All we're doing now is putting in a new inner tube in a new route that we're going to overinflate. That's how this project works. First you put in the pipe, and then you put in more pumps along the way. And eventually you have an oil leak or an oil spill. I know we don't want to talk about those things in the places where they're important, but I live in an important place. And I live in Ball Club right along Highway 2, where all the pipelines run. I watched the oil fire and spill in Cohasset in 2002. The largest oil spill in the North American continent was in Grand Rapids, 30 miles from my house. Cohasset's, 15 miles from my house. Clearbrook, another fire, an explosion. That's about an hour or so, hour and a half from my house. I look at those pipelines, and then I see the Husky fire. And then I look downstream, and I see Kalamazoo. And so as I sit here, I see continuous permitting, and I see continuous risk. And so when we come here to see whether or not the EIS or the supplement here for the spills into Lake Superior are adequate, they're not adequate. They're being designed in a way to look adequate, and adequate is like the minimum measurement of anything. Adequate usually isn't a word that talks about quality. Adequate isn't a word that talks about protection. And so when I talk about the resources that we rely upon, those are the same resources that everybody else wants to rely upon. And we'd like to have them all in place and protected. And we don't see where that's going on because all we see is permitting. Now, when I look back at Sandpiper, that was 6-7 years ago almost now. And all of a sudden they left town. And then they've come back with Line 3. But I don't see much change in the gas price across the nation. I don't see where we need any more extra gas or oil put through our territories to satisfy the need that exists everywhere else if you drive around. It's not a reality. It's just giving them something for free at our risk and peril. And so when I look at the treaty rights, we raised them during Sandpiper because we thought the state might recognize them, but they didn't. And so instead of raising them here with the PUC again, we're going to raise them in the appropriate places where our water quality rights are recognized. And so it's hard to rely on this and feel good that we're going to have the protection and the wholehearted interest because, as was mentioned, even the Namaji site didn't have an EIS. So we don't think in a big way that we're being watched out for. And that's the real sad part of this. If I have some time left, I'd like to give it to Dawn Goodwin if I could. She's one of our tribal members who lives on the reservation. Thank you.
Good morning.
Bushu gagage yashi kindishinakaz gawaba bigani kagan dunjaba maingan nindudame. My name is Dawn Goodwin. That's my English name. My native name means everlasting wind. I come from White Earth, and I'm from the Wolf Clan. It is my inherent responsibility as a member of the Wolf Clan to protect the environment and the people. And that's why I sit here today. I was denied the chance to speak during the first round beyond the deposition hearing with the administrative law judge. I was troubled during that time as I listened to all the deliberations. And Commissioner Tuma referenced that he did not understand our connection, the Native American connection to the land. He likened it to a romantic relationship. I was appalled. I felt very disrespected in those words, but I could not speak that day. I listened and waited for this moment to be before you. I don't think that is fair, that he's able to make that choice for our people when he does not understand a relationship to the land. We're culturally, historically, and spiritually connected to the land. Everything we have, everything you have, comes from the land. And we're at a time where we've taken too much, and our economy is at the detriment to our natural environment. So I want to speak more specifically to the adequacy of that final environmental impact study. It could not be adequate. And why I say that is because during my study about tar sands, this is the particular oil that we'll be going through. It's different than other crude oils. It sinks in water. And the National Academy of Science states that there is little study on the effects of tar sands oil on living organisms. So how could the study actually be inadequate? So this document that I got this from was a book, The Effects of Tar Sands Oil in the Environment and the Water. And it states in there that most of the study or most of the information that was compiled in there was with conventional crude oil. Very little with tar sands. So I stand strong in saying that it could not be adequate if there has been very little study done on the effects. And another thing I want to also mention is that emblem or state seal behind you, 1858. The reason why everyone here is here and the people live here, you all live here in Minnesota, is because of our treaties. And specifically the Treaty of 1855 is where I live, along this preferred route in Bagley, Minnesota. We signed that treaty, and it wasn't for us. We weren't given those rights. The signature on that treaty was to give the settlers the right to come to this land and settle. And so our deal was that we would allow people to come and settle, and that you could have your Minnesota state seal in 1858. And I want you to look at that further. You see a Native American in the background, and you see the man on the plow, living side by side. And so we made that agreement that you could all come and settle this land, and that we would live in peace. And we're coming to a time now that our treaty rights are being put at risk. And one last thing I want to add is, I say here for all of my people, I speak on behalf of Louise Silk. She is our White Earth Elders Council chairwoman. And she is also opposed to this adequacy or inadequacy of the study. She's also opposed to the certificate of need and route permit. And I want to speak specifically on my brothers and sisters from Fond du Lac, because what you don't understand is that the people constitute the tribe. And 5 elected officials have not given their people the free, prior, informed consent. The people of Fond du Lac have not said it's okay to do this and continue to do this. It has disrupted their lives, and it will continue to disrupt their lives even more, including mine and all my people. Miigwech.
Thank you. Climate interveners are next.
Good morning, Chair Sieben, Commissioners. It's been 3 years since we first intervened in this process, and a year and a half since the last time we spoke to you. Commissioner Means, I believe this is the first time we've met. It's good to meet you. To briefly introduce us, I am one of the 13 youth climate interveners. The others are Akila, Andrea, Francis, Isabel, Jada, Jordan, Margaret, Nina, Nolan, Rose, Sarah, and Sophia. We intervened in this process 3 years ago. A group of young people, ages 15 to 23 at that time, because our futures are at risk from climate change. And because we've grown up watching our government do nothing, again and again and again. We represent ourselves because we believe that as young people, we have a responsibility to speak directly to those in power, to tell our own story. And we've written briefs, submitted expert testimony, examined witnesses, and argued before this commission. And now, thanks to the Court of Appeals, we're back here to do so again. A lot's happened since June 2018. All of the youth climate interveners have finished high school now. Some have finished college. One of us was just at the UN climate talks in Madrid. One of us got his master's degree. One of us got engaged. We've been growing and taking on new challenges and adventures. By all accounts, as a group of young people now aged 18 to 26, we should have bright futures ahead of us. But of course, a lot else has happened since June 2018. In October 2018, the IPCC published its special report on global warming, warning policymakers like yourselves that we're running out of time to limit warming to 1.5 degrees Celsius. In June 2019, President Trump unveiled his rollback of the Clean Power Plan. In December 2019, the UN once again failed to make meaningful progress in climate change talks. So honestly, commissioners, being young people in 2020, it feels a bit like we're banging our heads against a brick wall sometimes. But we still have hope. We have hope because in September 2019, Governor Walz announced or ordered the PCA to implement new zero-emission vehicle standards. We have hope because in September 2019, more than 7 million people around the world, most of them younger than us, took to the streets to strike and demand climate action. We have hope because it's 2020 now, and Line 3 still has not been built. And commissioners, we intend to keep it that way. We have up to 3 chances to address you this week. First on the FEIS, second if we get there on need, and third if we get there, I hope we do not, on route. So a few things for now on the FEIS. It's been said many times that this has been the most studied pipeline in Minnesota history, but that only matters if we look at what those studies say. First, the revisions to the FEIS don't achieve what the Court of Appeals asked for. The court asked the commission to look into the potential impact of a spill on the Lake Superior watershed. That's a big place, but the FEIS looks at just one potential spill site on one of the multiple tributaries that Line 3 crosses that flows into the lake and calls it a day. The FEIS also limits its analysis to only 24 hours, even though it acknowledges that oil could flow for longer. Oil could leak for longer. After the Kalamazoo spill, the pipeline wasn't even turned off for 17 hours. The response time assumptions are also flawed. I mean, you have testimony in the record from Mr. Baumgartner that some of Enbridge's leak detection thresholds are 24 hours. The FEIS also inadequately analyzes different seasonal conditions, variable weather or storm conditions. Wind speed, rainfall, and other factors can have a big impact on the flow of oil, and the FEIS isn't clear enough about what a worst-case scenario is. Second, a lot has happened since the first DEIS almost 3 years ago. Those 3 years have given us 3 years of the no-action alternative, which puts us in a better place to assess the alternatives in the EIS. EMATAs haven't come true. And today we know that in the last 3 years, we have not seen 1,900 trucks per day of oil driving through Minnesota as a replacement for Line 3. We have not seen several hundred oil train cars per day as a replacement for Line 3. By all accounts, oil transportation in the last 3 years has looked a lot more like interveners' predictions than Enbridge's. So the alternatives analysis in the FEIS wasn't reasonable then and is definitely not reasonable now. That section deserves another look. Third, I want to restate one of our earlier directions to this FEIS. We still believe that the FEIS should account for greenhouse gas emissions, oil spill risk, and other operational impacts beyond the minimum economic life of Line 3. Enbridge has expressed no commitment to turning this line off after 30 years. So to cut off the analysis of impacts at that time is an abdication of this agency's duty under MEPA to look at all of the effects of this project. If Line 3 could run for longer than 30 years, and Enbridge seems to think so, then those impacts should be accounted for in the FEIS. The FEIS should also examine the impact of the eventual decommissioning of Line 3, an inevitable consequence of building it. Currently, the FEIS acknowledges those impacts, but it does not meaningfully quantify them. Finally, to conclude, we want to remind the Commission, while the FEIS remains inadequate, the record still contains all the information you need to stop Line 3. If we get to a discussion of a certificate of need today, we have every hope that you will make the right decision. Thank you.
Thank you.
Anin Indoy Maganaduk, hello. Binisikwe indigenica smakwando dam, Gababani ka gish kanaganing and Dunjaba miigwich, Nishnabaya king and Dunjaba. So I'm Winona LaDuke from Honor the Earth. We know each other because I've been coming here for 7 years. For 7 years, I've driven down from my reservation in northern Minnesota to your hearings. I've done that because I want the system to work. I want the Public Utilities Commission to be the Public Utilities Commission and not the Corporate Utilities Commission. I want the Public Utilities Commission to make good decisions for the people of Minnesota, for the land and waters of Minnesota, and with good regard for the Anishinaabe, who you can see are fully represented here in their opposition to this line. I'm here because I want the system to work. So when I left real early this morning, as I do every time, it makes you think. In 7 years, I've had 4 grandchildren born. And I think about what I'm supposed to tell them about this whole 7 years. Why I wasn't there, or maybe why Dawn wasn't there. What we were doing down here, did it matter? Did it matter? Did 68,000 people pouring out their hearts to you, crying at hearings about the impact of this line have any effect on you? What are we worth? What are we worth to you? That's kind of the question I have to ask. So in the specifics of the EIS, I've got a lot of academic training, and we've succeeded in compartmentalizing things really well. And so you're supposed to look at this one thing, the watershed. But as everybody here has already explained, first of all, looking at Little Otter Creek was entirely inadequate. And it's interesting because, in the big picture, say that you are from Anishinaabe-King and you're Anishinaabe-Kwe like myself. Our landscape is Lake Superior. Our entire world is these waters. This is the place where the Creator put us. In my comments on the EIS, I submitted a Medewan scroll to you all. I'm sure you've never seen anything like that. But, in our teachings, which is like a 5,000-year-old religion, we have a migration scroll which shows the Namaji River on it. And it shows the St. Louis River. It shows a lot of the lakes, including Leech Lake, impacted by the present Line 3. It's not a specific, it's not a specific place. We have a much broader than a compartmentalized vision. We have a landscape understanding that precedes the state of Minnesota's. And so I feel like that the Namaji River discussion, which has been brought forth by the other attorneys, is pretty clear. It is rather a shame. We want the system to work, but 3 times you guys were court ordered to do an environmental impact statement. 3 times. On the Sandpiper, on Line 3, and now on the Namaji Trails project. You clearly have the responsibility to look a little bit out of the state of Minnesota, because the Namaji is already heavily impacted by all of this oil, all of this destruction. During the time that we have been here talking, to y'all, I was given a tar sands ball, which was submitted to you on Friday, I believe. I'd like to bring the ball again. In 2015, someone collected a tar sands ball from the bottom of the Kalamazoo River for me. 2015, that would be 5 years. 5 years after the Kalamazoo spill. Because the oil doesn't stay on the top. Even if the Army Corps of Engineers had a boom, which they're going to have to import from the Gulf of Mexico if there's a spill, which we better get that in place right now, the fact is that oil's going to sink. And although we've successfully seen all kinds of studies on risk assessment, new pipes spill. That's what just happened with the Keystone spill in South Dakota. That would have been a pipe, the new Keystone pipe, less than 10 years old, 823,000 gallons. Pipelines break. Pipelines spill, even new ones. And so, I sit here and look at this Great Lakes watershed or the Superior watershed. And, I cannot tell you how significant it is to the Anishinaabe people. Our sacred place is in the middle of Lake Superior. How am I supposed to tell my ancestors or my descendants that I protect it? And then the bigger picture to me is that, you have access to all of the information that would allow you to make the right decision. I cannot present any more facts For 7 years, we're presenting facts to you. You know, and you all live in the same world I do, I think. At some point, you know, we got to reckon with what we're doing, and at some point, you just have to say no. Enough would be enough. The risk that is posed by Enbridge is immense. The ability to assess a cumulative impact of this spill that they will have at some point on Superior must be also matched with the impact of a spill that is quite possible at the Straits of Mackinac. Enbridge has said in the Straits of Mackinac that's a $6 billion cleanup. Kalamazoo was a $1 billion cleanup. What security do we have that a 60-year-old corporation will be able to manage any of that? What security do we have in any way as Anishinaabe people? You know, that was a 17-hour spill, but all of the risk posed by this corporation to us is so significant. We really feel that we know that the EIS is inadequate. We know that you have the opportunity to really fully review this. And I really feel that, you know, due diligence on behalf of an agency that looks with such gravity and breadth at this situation is required. You know, and so I submit to you, quite frankly, that the EIS, as everyone else has said, is inadequate. And I know that you know, you are here probably to just kind of pass things along because you don't want to do the EIS. But the right thing to do is to say no, and to say that the EIS needs more work and that this project is in itself inadequate. For 7 years, I've come here to say the same thing. You know, my children, my grandchildren are going to be trying to drink this water, and less than half of the water in the state is good anymore. Superior is a fifth of the world's water. What are you going to say to your grandchildren? What are you going to say to future generations about what you did to protect the water? This is your shot. So I hope you do the right thing and ensure that a full and adequate EIS is done that addresses, you know, not only this one little Otter Creek, but a much more broad scale, as the courts have said that you may do. Thank you.
Thank you. Ms. Freelander.
Good morning, Chair and Commissioners. Thank you for the opportunity to speak today in support of this important project and choice. I'm here representing the United Association of Plumbers and Pipe Fitters, which is a labor union representing over 350,000 highly skilled members in the industry, the pipe fitting and plumbing industry across all of North America. I think it was something like over 4,000 comments that United Association members filed during the public comment period because they're proud and they're committed to upgrading our vital energy infrastructure, which is exactly what the Line 3 replacement project does. The decision before the Commission today boils down to two different questions. First, is the FEIS adequate now that it includes an analysis of the project's potential impact on Lake Superior? You just heard an explanation of how the Little Otter Creek site was selected and how many other choices were considered. This Court of Appeals already approved of the spill modeling that was used to come to that decision for the 7 other sites, and there's no reason to second guess how they employed that spill modeling here. Basically, the FEIS took the revised one we have today. It took the most likely site for a spill affecting Lake Superior, and then it modeled it. And if you want to hear about an academic argument, I see it as the ones that second guess the details of exactly what the ERA was supposed to do and how they were supposed to frame it. Because the bottom line is that they took the most likely spill site to affect Lake Superior and they analyzed it. So then you get to the question of what the Commission should do now that the FEIS has been revised. And on that point, the revised FEIS and its determination that the Line 3 replacement is unlikely to affect Lake Superior only confirms that the Commission did the right thing a year and a half ago when it issued a certificate of need for the project. And it comes down to the same question as it did then. Is it better to replace an outdated, unreliable product with a state-of-the-art modern pipeline that would greatly improve safety in Minnesota for decades, or to stick with what we have now? Two of the four factors you have to consider when you decide on a certificate of need ask you to look directly at the consequences of denying it. And those are whether denying the certificate of need would be likely to adversely affect the future adequacy, reliability, and efficiency of crude oil supply to Enbridge's customers, the people of Minnesota and the region, and whether the consequences to society of granting the certificate of need would be more favorable than the consequences of denying it. And it was abundantly clear how seriously the Commission took that decision the first time around and how deeply felt it considered the consequences of not granting the certificate of need, which is that Line 3 will continue in operation and that's a relatively dangerous proposition. And I've heard a lot of people today wanting you to focus on the hypothetical effects of the Line 3 replacement, but I didn't hear any of them talking about the effects of Line 3 remaining as it is now. So I'll just end by echoing what Mr. Benoit said at the beginning. Let's not fail to see or ignore that that's the forest that we're in. Let's not ignore the overwhelming benefits of upgrading an aging and unsafe product with a new one that provides the greatest possible benefits to Minnesota and the region. The revised FEIS confirms that that's the truth, and it remains the best choice before the Commission. Thank you.
Thank you. Good morning.
Good morning. Thank you, Madam Chair and Commissioners. The second revised EIS is adequate. It meets the 3 adequacy criteria that you have under Minnesota law, and it addresses the narrow issue identified by the Minnesota Court of Appeals June 3rd, 2019 order. Namely, it provides an analysis of how Enbridge's Line 3 project would impact Lake Superior and its watershed. As Chair Sieben quoted at the start of today's meeting, the court found that the FEIS complies with the Minnesota Environmental Policy Act in all other respects. And importantly here, the court found that the EIS utilizes an appropriate methodology to analyze potential impacts from oil spills, affirming the Commission's use of representative modeling sites and the underlying assumptions used in the spill model. Several parties and commenters have suggested that a different location, additional locations, or different assumptions should have been used in the modeling. None of these arguments lead to a legal inadequacy, and they're all points that the court has considered and rejected. As it relates to the use of representative sites, the court stated, an impact of any particular spill will depend on multiple variables, many of which are subject to chance. Rather than attempt to predict the consequences of an oil spill from a particular location, the FEIS focuses on analyzing the potential resources impacts of a spill at all locations along the applicant's preferred route and the alternatives. The FEIS itself also addresses this issue in section 10.3.2, stating it's not practical to model along the entire route. And further, section 10.3.4 of the EIS provides an equivalency table. It's table 10.3-2 that allows the public and decision makers to gain an understanding of the potential effects of a spill at other water courses that may be of interest. Now, Honor the Earth, Mille Lacs, and Friends have attempted to take this site selection issue even farther, asserting that the EIS is inadequate because it doesn't include one or more modeling locations in Wisconsin. This argument fails for at least 5 additional reasons. First, while Honor the Earth goes to great lengths to insert what they think the court should have said in its order, what the Court of Appeals actually said was that the Commission needed to, quote, address the impact of an oil spill on the Lake Superior watershed, end quote. The court did not call out any particular locations, but they left that to the expertise and the judgment of this commission. Second, the court's language is consistent with the final scoping decision document, which was at issue in the court's opinion. It said that the FEIS would consider the potential impacts of oil spills to the Lake Superior watershed. Third, on remand, the agencies and the technical consultants considered approximately 150 sites, including sites in Wisconsin, and the FEIS itself documents why Little Otter Creek best fit the criteria previously used in site selection and offered a more representative site because it maximized the effects over a larger portion of the Lake Superior watershed and had the greatest potential to reach Lake Superior, particularly when you compare that to other slower moving and flat water bodies like those crossed by the Wisconsin portion of Line 3. It's important to understand that closer to the lake doesn't mean a greater potential to reach the lake. Velocity and volume matter. Little Otter Creek had the greatest potential to reach Lake Superior because it flowed into the faster, larger water body that drained into Lake Superior. Fourth, these facts are much different than the NTEC case. Here, there's no future physical activity in Wisconsin being done by a Minnesota public utility. The segment of Line 3 in Wisconsin went through a full environmental review with the Wisconsin DNR. It was fully permitted, constructed, and placed into service in May of 2018. Accordingly, the Commission is not authorizing future physical activities in Wisconsin, and those physical activities would be exempt anyway under MEPA review under the provisions in Minnesota law, in Minnesota Rule 4410-2000 and 4410-4600. And finally, the revised EIS did analyze the potential significant human and environmental effects of a potential oil spill into the Lake Superior watershed at the Little Otter Creek, including those effects in Wisconsin on the St. Louis River, the estuary, and Lake Superior. Those resources and the potential impacts are all clearly discussed in Chapter 10 and Appendix V of the revised EIS. For these reasons, a lack of a Wisconsin spill modeling location does not make the EIS inadequate. Accordingly, the Commission must find that this revised EIS is adequate under Minnesota law. Enbridge respectfully requests that the Commission approve decision option A1 on page 25 of the revised briefing papers, finding that the December 9, 2019 second revised EIS is adequate. And we ask you to move forward with the certificate of need and route permit approvals for this important integrity and maintenance project. Thank you.
Thank you, Ms. Brusen. We're going to take a approximately 10-minute break now, and so the Commission will be in recess. If everyone will please be seated, we'll begin in a moment. Ms. Miltage, I know we are going to have questions for you. If you would please come forward. This portion of the proceedings will be time for commissioners to ask questions of the official parties. Commissioner Means indicated that she would like to begin, so Commissioner Means, please.
Thank you, Chair. Can everyone hear me? Good morning.
Good morning.
I want to discuss the site selection and modeling analysis, and I want to understand and confirm really the context in which some of the decisions were made. And as I understand it, there is no single universally accepted, applicable EIS methodology, if you will. And for purposes of this project, no set standard EIS methodology to analyze potential impacts of an oil spill that has been adopted in Minnesota. Is that correct?
Madam Chair, Commissioner Means, that is correct.
And is it also correct that the department began investigating oil release modeling in July 2015?
Madam Chair, Commissioner Means, that's correct.
And subsequent to that, the record indicates that the department worked with assisting state agencies and federal agencies and a private consulting team of experts with respect to the selection of sites for hypothetical releases and to develop specific assumptions about a release for use in the modeling analysis. Is that correct?
Madam Chair, Commissioner Means, that's correct.
And the state agencies involved, in addition to the department, included the Minnesota Department of Natural Resources, the Minnesota Pollution Control Agency, and the Minnesota Department of Agriculture.
Madam Chair, Commissioner Means, I believe that's correct.
And the federal agency that was involved was the U.S. Army Corps of Engineers.
Madam Chair, Commissioner Means, correct.
The site selection process that was developed was also informed by important considerations raised during the scoping process by members of the public and the communities that would be affected by the project.
Madam Chair, Commissioner Means, that's correct.
Is it fair to say that the development of the modeling analysis was a labor-intensive technical endeavor?
Madam Chair, Commissioner Means, it was, certainly.
7 representative modeling locations were selected for detailed modeling and assessment for hypothetical release to represent likely outcomes, correct?
Madam Chair, Commissioner Means, that's correct.
And is it true that there are thousands of pages of data in this record that detail the very technical aspects of the modeling and assessments of likely impacts following a hypothetical oil release?
Madam Chair, Commissioner Means, that's correct.
And I read through all of those reports. The Commission issued an order finding the first revised EIS adequate on May 1st, 2018. And is it your understanding that the Court of Appeals upheld the representative model approach as used in that FEIS?
Madam Chair, Commissioner Means, yes.
Would you discuss and refresh for the record the choice to do the same modeling approach in the second revised FEIS that the department did in the previous FEIS?
Madam Chair, Commissioner Means, after we received the decision from the Court of Appeals, we looked at the various points that were made in the decision by the court. It appeared to us that they'd upheld the methodology that we had worked on over the course of several years and that we had vetted with our other agencies and through the scoping process, through comments on the draft environmental impact statement and through our development of the final environmental impact statement. It was our opinion that that was the appropriate methodology, and to continue using the same methodology we had previously used was very important to us. We wanted to stick to all of the same assumptions, all of the same underlying ways of doing things that we had originally used.
And Little Otter Creek was determined to be the location within Minnesota where a hypothetical oil release was most likely to enter the St. Louis River and ultimately more likely to have the potential to reach Lake Superior than the other options considered. And you heard quite a few of the comments this morning and the written comments previous to that with the concerns with that selection. Could you refresh the record also on the selection of Little Otter Creek?
Madam Chair, Commissioner Means, in the selection of the 8th site, we went back to the purpose of the modeling, which was to give us an understanding of how oil could behave, large amounts of spilled oil in various environments across the project area. We went back to that original purpose of the modeling, and we had some specific categories that we had used in the original modeling to identify sites, different kinds of characteristics we wanted to be sure we spanned. You'll see in the environmental impact statement a table that outlines those different characteristics that we were trying to make sure we covered with our different modeling sites. Excuse me. So we revisited those criteria, and we looked at the original work that had been done by that interagency body, where we had looked at more than 1,000 sites. We brought that forward again, looked at all the different water courses. We narrowed it down to the greater than 100 water courses, major water courses crossed in the Lake Superior watershed. And Little Otter Creek rose to the top as a site with, you know, it hits a lot of the categories. It's a small water body at the beginning. It widens into a very large water body. It's got fast-moving water. It's got the complication of there being a dam there and the potential for entrained oil and sinking oil. Furthermore, you know, it ultimately flows to the lakes, to Lake Superior itself. By contrast, there were other sites we could have looked at that were further away, didn't check as many of kind of our physical characteristic boxes, if you will. The sites in Wisconsin, for example, are small, relatively slow-moving waters. And you'll see in the EIS a discussion of how those sites were considered and ultimately rejected, because we were looking back at that original purpose of the modeling and trying to get a robust picture from a single additional site.
Thank you. And I've read all these thousands of pages of this document and the supporting documents. Is there anything else that you'd like to state publicly for the record to help the commission make its decision today?
Madam Chair, Commissioner Means, I don't have anything additional to add at this time. I think you've got everything you need before you, and your questions have been helpful. The body of work before you is certainly robust, and I'm happy to answer any questions any other commissioners have about where anything specific is in those documents, but it is all there.
Thank you. I don't have any further questions on modeling.
Commissioner Sugar.
Thank you, Madam Chair. Ms. Miltage, how do you define the Lake Superior watershed?
Madam Chair, Commissioner Sugar, the Lake Superior watershed, or a watershed in general, is not, you know, defined by us. It's an objective thing. It's a physical thing. It's a physical area of land that drains into a water body. In the case of Lake Superior or the Great Lakes, there is a larger watershed that is called the Great Lakes watershed. In the case of Lake Superior, when we say the Lake Superior watershed, we are talking about the Great Lakes Basin, the area that drains into Lake Superior. It's made up of many smaller watersheds, but that's...
And approximately how large is that? I mean, how would you describe it or characterize the Lake Superior watershed?
Madam Chair, Commissioner Sugar, it's a very large watershed. I can't tell you in terms of number of acres, but.
It's huge.
Yes.
And can I find, just direct me to where in the FEIS I can find that description, characterization of the Lake Superior watershed, this vast and huge area that you considered when you were responding to the Court of Appeals.
Madam Chair, Commissioner Sugar, I'll refer you to a map in Chapter 10, I believe. Actually, my apologies, it might be in Appendix V.
You're looking at figure 1.2?
In Appendix V? Or in?
Oh, I'm sorry, go ahead. I'm working ahead.
If you'll give me just a moment.
I'm in Appendix V, but wherever you find it, I'd like to.
My apologies. Try figure 3.4.
Page 3.31. I think that's what you're probably referring to. They kind of look like watersheds.
Yep, let's turn to figure 3.4.
Where are we, Ms. Milchich?
Commissioner Sugar, can you restate your question? I lost what it was.
My question was, how are we defining, how's the department, ERA, defining the Lake Superior watershed? And Ms. Milchich was going to refer me to a map.
And actually, it doesn't look like the watershed now that I look at it. Because Rainy goes north.
So is there not a description in the second revised FEIS of the Lake Superior watershed?
Madam Chair, Commissioner Sugar, I'm not finding it at my fingertips here. The Lake Superior watershed, or the Great Lakes Basin watershed, is as defined by the hydrologic unit codes. It's a known.
It's not defined in the second revised final.
No, we did not define it ourselves as a separate thing.
I'm perplexed by that, as you received a remand from the Court of Appeals to study the impacts of an oil spill on the Lake Superior watershed. It seems to me the first task would be to assess what that is, to do that. So let me just move on from that. I do understand that you looked at a number of sites that are within the watershed. And I wanted to ask you about a couple questions related to your selection of that set of sites. And this was alluded to in opening remarks, but can you help me understand the criteria that you used in selecting Little Otter Tail Creek? One of the criteria you note is that no Line 3 construction for this project has occurred at the site, and you contrast that with the Wisconsin sites where construction has occurred. Help me understand why that's relevant. Clearly, we're, under the applicant's proposed project, we're increasing the volumetric flow significantly in this pipeline if approved. We're increasing the pressure in the pipeline. A spill on an existing constructed pipeline in Wisconsin does have impacts, changes as a result of this action that's before us, and does potentially have impacts on Minnesota. So why are those criteria listed? Construction already occurred or did not already occur?
Madam Chair, Commissioner Sugar, it was one of many considerations. The fact that that segment of the line has already been reviewed, permitted, and constructed in Wisconsin was just one of the considerations in terms of adding new data to the universe of information that's available about the potential impacts of constructing and operating the line. And I acknowledge that the throughput as a result of your decision could change. But that was one of the many considerations, just the simple fact of the review, permitting, construction, and operation of that new segment of Line 3 already in Wisconsin.
But you would agree, Ms. Miltage, that consideration of that site is relevant to the decision and action before us, regardless of whether or not it's already been constructed? Would you agree?
Madam Chair, Commissioner Sugar, I agree.
Can you talk, Ms. Miltage, a little bit about your reliance on the Wisconsin Department of Natural Resources environmental review? I understand an environmental review took place. Clearly, they have different requirements and approaches to their environmental review. I understand the purpose of that environmental review to be for what's physically being built in that state and for impacts on that state. But of course, the question before us today is, what are the impacts as a result of the action here? And how could spill at these Wisconsin sites under the conditions that result from our potential actions, increased flow, increased pressure, impact Minnesota? So what is the rationale for relying on an environmental review that's of a different scope and a different purpose?
Madam Chair, Commissioner Sugar, I would encourage you not to rely on just the review that was done in Wisconsin.
I'd misunderstood. I thought that I understood from the second revised final environmental impact statement, as you listed that environmental review had been done, that in fact you were relying on it.
Madam Chair, Commissioner Sugar, I believe it supplements the record that you have in front of you. We reviewed many potential sites within the Lake Superior watershed. We looked at the potential impacts of spills in a number of other ways beyond just the representative spill modeling that give you information about the potential impacts of an accidental release along the entire line, including Wisconsin.
Thank you. But you would agree that, in fact, we cannot and should not rely on the environmental impact statement that was done in Wisconsin for our purposes. I'm not suggesting any judgment on their process for their purposes, but you would agree that we would not rely on it for our questions before us today.
Madam Chair, Commissioner Sugar, I would agree with that statement. You should not exclusively rely on that information, and I think the record before you contains much more than that.
Thank you. I do have a couple more questions, if I may. Ms. Miltage, I wanted to ask you about the analysis of Site 8, the little Otter Creek site. And you mentioned the Fond du Lac Dam in your earlier comments, but does that not have a significant containment effect? Is there not somewhat a reliance on that for containment? And did you look at scenarios where that dam is potentially not in place in the future? Or did you assume that that dam is in place in perpetuity?
Madam Chair, Commissioner Sugar, just to be clear, in the modeling, it was assumed that the dam was not closed, so it was not containing the oil or holding it back. I don't know whether or not that would be a measure that could be put in place in the event of a spill, but just for clarification, the assumption was that the dam was allowing water to flow through. We did not look at future scenarios where the dam would be removed entirely or that stream morphology in some way significantly altered. We just worked with what is physically there at this time, but I would offer that clarification that we weren't modeling it as something that was holding the oil back.
Thank you. Ms. Miltich, I'd like to ask you about the assessment of the Duluth Superior Harbor. It's noted in the second revised FEIS that because it's an industrialized site, it's less important to assess environmental impacts. At least that was my understanding of the FEIS. Am I understanding that correctly? And why is it less important? Because the site is industrialized.
Madam Chair, Commissioner Sugar, I wouldn't characterize it as less important, but it, from a modeling perspective, gives us fewer, there's less kind of shoreline oiling that could occur in terms of natural resource impacts and kind of the behavior of the oil. The industrialized nature and the characteristics of those stream banks were, from a modeling perspective and from a general understanding of how natural resource impacts might occur, was less compelling.
Are not sociological and economic impacts also within the scope of the FEIS?
Madam Chair, Commissioner Sugar, certainly, but those like the stream banks where you have more topography or more vegetation, the oil behaves differently as opposed to stream banks that are more, developed concrete. It's just less of a compelling range of behaviors that you'll see.
Thank you. So, still important, but different.
Correct.
So, you would agree that it's important to assess the estuary, the harbor, as well as the lake?
Madam Chair, Commissioner Sugar, I believe that through the representative modeling approach, we've covered a wide range of characteristics, and yes, I believe that's one of the types of locations that could be important.
Ms. Miltich, we have in our record information regarding relatively recent analytical scientific studies of the impacts to the environment, to humans, of bitumen and dilbit. Has the current research and understanding of the impact of this specific oil that will be transported been incorporated in the FEIS? And if so, could you direct me to those studies in the FEIS?
Madam Chair, Commissioner Sugar, we did not do any additional studies or draw on any additional body of work.
You have not included the relatively recent studies or analysis. Was there a literature review done at this stage to ensure that you were incorporating current research and analysis related to the impacts of bitumen and dilbit to the environment, to humans?
Madam Chair, Commissioner Sugar, we did not initiate a new literature review.
Thank you. I have one final question. The Court of Appeals in their decision did address a particular aspect of the impacts of climate change. They did address a particular question that was framed to them on climate change. And part of their decision in the Court of Appeals on that particular question of climate change, in my read and understanding, reinforced that the FEIS does importantly bookend the impacts of climate change, does recognize the full range of impacts from zero displacement up to full displacement, that the second revised FEIS does show that those impacts of climate change can range up to 193 million tons of CO2 and $287 billion of social carbon cost. But what they didn't address, and what seems important to me in this environmental impact statement that's before us, is the considerable additional understanding we have of the impacts of climate change on the weather, on the environmental conditions, on the rain incursions that we're to see in these areas, on the water flows of the river. Did you in any way incorporate current scientific understanding of climate change on the conditions in the river, in the weather patterns, in the rain flow, in this current analysis? Or did you simply pick up the same models that were used previously, which are prior to recent assessments that were done since the original FEIS was done?
Madam Chair, Commissioner Sugar, we used all of the same modeling approaches that were used in the original EIS.
Thank you. I have no further questions.
Ms. Miltage, was the information provided regarding the impact of a spill on the Lake Superior watershed based on the most up-to-date information available? And when was the analysis on the Lake Superior watershed done? It's not a trick question. I'm just asking, like, when did you actually do the modeling for the second revised EIS?
Madam Chair, the modeling for the second revised EIS was completed this fall.
And in your estimation, is that the most up-to-date information that was available?
Madam Chair, at that time, it was.
Right. And again, I think that Commissioner Means covered this earlier, but is the way that the Little Otter Creek site was selected for representative modeling consistent with the ways the other locations from the previously approved EIS, consistent with the same ways the other sites were selected in the EIS prior to this?
Madam Chair, yes, we applied the same decision-making framework.
Thank you. And after seeing the comments filed and hearing the questions this morning from the opening comments from parties, do you think, because you were so intimately involved in the creation of this second revised EIS, that any further information is needed to supplement it now?
Madam Chair, I do not.
Commissioner Tuma.
Thank you, Madam Chair. Scott, if you could get the, I think it's figure 1-2, not to be confused with figure 2-1. So up. As he's getting that up, Ms. Miltage, I do want to cover one. I'm looking at the revised FEIS at page 1057 and 1058. That's where you have the discussion of the Little Pokegama and Pokegama rivers. And so I read through that. And
Commissioner Tuma, sorry, one more time, could you say where it is?
Yep, it's in the FEIS, the revised one at 10-57. I don't see the actual chapter number there because I'm down from it. Yeah, it's 10/57, 10/58. And this is where you distinguish, and you actually did look at the Wisconsin rivers. It's not like you were ignoring the fact that a spill on the Wisconsin side could affect the estuary and Minnesota because, as you can see on the map, it's connected. We neighbor each other there, and so impacts in Wisconsin could very well impact Minnesota. But I see you lay out some facts for me. I guess I'm looking on this page, and you say that some of the reasons it wasn't included was Line 3 project has already been reviewed, approved, and constructed. And as we find out today, in use since May, was it, of this last year, it's been in service. Yes, it's going to get more oil. Theoretically, it could get potentially oil from other of those pipelines too if they decide to interconnect them at that spot, which they would probably have every right to do. And you also highlight the fact that this is going to affect areas that are industrial in nature. You just lay out facts for me. You highlight a Wisconsin statement, but you say very clearly in there that this was not a full analysis, so you weren't trying to pawn it off on me as a full analysis from Wisconsin. So I think you were just giving me facts. Was that your goal here, just telling me information, which I think is the purpose of the FEIS?
Madam Chair, Commissioner Tuma, that's correct, and we wanted you to have that supplemental information at your fingertips from the Wisconsin EIS, should it be somehow helpful.
I was trying to read in here where you're telling me that you're giving me legal advice. I know you're real smart. You went to Carleton from Northfield, so you're very intelligent, but I don't think you have a law degree. I don't think you're trying to give me legal advice here. You were just giving me factual advice. Is that correct?
Madam Chair, Commissioner Tuma, I'm in no position to give anyone legal advice.
Thank goodness. I probably shouldn't either, but nonetheless, they gave me a license. So I'm looking at this. I just want to be clear. You are not trying to make a legal declaration to me in any fashion, in any way, for me to rely on and say, legally, you're not supposed to pay attention to the Pokegama or the Little Pokegama.
Madam Chair, Commissioner Tuma, that's correct.
Let's talk a little bit about that selection, just so I can get a context. I think it's all here, okay? I don't need to correct what's here, but I just want to make sure I highlight and understand what's here and make sure my decision is accurately reflected in the documents that you have. I put up on the map the areas where you were identifying the different sites within the Lake Superior watershed. I have no problem understanding what the court meant. The court's not a watershed scientist. I think it's pretty clear the chief judge who wrote the orders from Duluth, he was saying, you guys need to study the impacts on this significant thing called Lake Superior, the estuary, and the one river that we're going to impact, okay, significantly, the estuary itself and the St. Louis watershed or the St. Louis River. I would include in that the Pokegamas too. And so as I look at this, you studied from where the pipe would join up to the main line, which is the route that was selected eventually by us. It's different than the original route. And you studied several different locations. Those were not the only things that you all considered. There was 100 and some, how many was there? 150 plus, I think, was what my recollection was. I don't have a disagreement, but when it came down to it, you said, here are those representative sites that make the most sense for us to study, and they included both the Pokegamas, right?
Madam Chair, Commissioner Tuma, that's correct. And as long as we have this up, I would like to take just a moment to point out for Commissioner Sugar, on this map, the sort of pink peach colored line outlines the portion of the Lake Superior watershed that's in the project area. So that water is draining into Lake Superior. So that's the approximate watershed boundary, and it's not a zoom out so you can see the entire expanse of it, but this is the area that was relevant to the potential impacts of the project. It's not something we define as the Department of Commerce. It's just physically the area that drains into the lake.
And
Go ahead.
Madam Chair and Ms. Miltich, as I read this document, it seems to me to be the conclusion of the water experts that you worked with
PCA, DNR, Ag even does have water experts in it, but I would lean on the PCA and the DNR. And in this revised document, it seems to be coming to the conclusion all of these that I'm seeing here, all of these watersheds from the East Savannah and everywhere in between to the Pokegama, under a full-bore, unlikely full-bore release, right over the actual stream, the most likely scenario is that very little, if any, of that oil is going to reach the big water, Lake Superior. Is that assessment fair?
Madam Chair, Commissioner Tuma, I think that is fair.
No less significant, okay? I don't think the court said, stop the analysis here. I think the press grabbed onto that factoid and it made it sound like, oh, we're done. But that's not what it said. I can read the court order pretty clearly, and I think you read it the same way. That's not the end of our analysis, correct?
Madam Chair, Commissioner Tuma, that's correct.
It's the estuary, the streams, lakes, and rivers that are in this pink area that we need to assess and define what is going on here, what's representative of this area. And I look at that area, and we've all driven through there, okay? We all come over the hill. You all seen it. You remember it. You come over the hill, and what do you see? Expanse, elevation drop, okay? Significant elevation drop. And I look at all these streams here that you are looking at. Which one of those is most representative of that elevation drop in the Lake Superior watershed?
Madam Chair, Commissioner Tuma, Little Otter Creek.
Yeah. I mean, if you could put the next map up, Scott.
Madam Chair, Commissioner Tuma, just bear with me. This is a little clunky. We have to do
2.1, yeah, you clunk away there. And in the, just remind me again where in the FIS I can find the representatives of the streams compared to the actual ones tested. That's in the FIS, right?
Madam Chair, Commissioner Tuma, it is. There's a table in Chapter 10, Table 10.3-2 that summarizes the characteristics of each of the representative release locations.
And so I put up here, I actually just highlighted, so this is it's in your document, it's the table, or actually figure 2-1. I only highlighted the areas just so that it stands out. So from left to right, highlighted in yellow would be the Little Otter Creek into the St. Louis watershed. That's that fast dropping, and as you see, there's a little box there that says rapids, okay? This is one area actually in Minnesota where you can actually rent a whitewater raft and take a whitewater rafting trip if you want to. And then in orange or gold to the middle would be the Little Pokegama, and then in the green is the Pokegama River that everybody's talking about. And when you describe in there the Little Pokegama River, I think you use terms like slow-moving, meandering, sinewy, which is curvy, for both of those describing. And so what stood out to me in this analysis of why Little Otter Creek was representative of this watershed is that elevation drop, the rapids moving fast compared to the Pokegama and Little Pokegama. If I want to make an analysis of those two rivers and the potential impact on Spirit Lake and the estuary, I have representative sites. I think of Sandy River or the Little Mosquito or the Mosquito River. Those would be representatives where they're telling me the water could move downriver, representative 3 miles to 12 miles. I have those things I can look at to give me a representative view of what's going to happen to the estuary and the Pokegama. Is that correct?
Madam Chair, Commissioner Tuma, that's correct.
And so what's critical here that you pointed out to me are two things in the FIS that really stood out and are helping me when I have to now make the next step and take the hard look at our decision on CN and route. And actually, in some ways, I'm sure my attorneys are going to cringe when I say it, I kind of think the court had something here because none of the other rivers have characteristics as fast of moving water as this particular course of water with the St. Louis and the Rapids. So I am looking at something that is significantly different than all the other representative rivers, and it is unique to this particular area of the state of Minnesota. So it is, I think, very helpful as I look at this because of that. And so speed, which you outline why speed is important. I read that in the appendix V. You point me there in the FEIS. It's one of the blue things that you make sure you highlight, make sure you go read that. So I did read it. And that's because of submerged oil, right? Submerged oil creates that tar ball that we looked at, right? The other thing that caught me was location here. What's critical, so when I look up at that map, I see a state park, okay? An iconic state park as far as I'm concerned. I've spent a lot of time there. I've seen the rapids there, the iconic Jay Cook State Park. And so that's significant. You also highlight a lot of restoration of habitat. Would it be fair to say that that restoration that you've been able to identify, it seems to be clear in here, most of that is what I call upstream in the estuary, would be essentially west of Spirit Lake or Spirit Lake and west. You highlight a sturgeon habitat that was restored for sturgeon spawning right below the dam, right? And that's the dam I see there. It can't just down below the word park there, that's the dam that we're talking about, right?
Madam Chair, Commissioner Tuma, that's correct.
And I won't make you come up, Ms. Van Norman, but I think you could agree with me, there's a significant cultural site right by that thing called dam, okay? You know, your reservation is called Fond du Lac, but that's not really where Fond du Lac is. It is right where that dam is and right below Jay Cook. And I drove through there to go through, like I always do, like to take the back route into Duluth. And there was a lot of cultural sites identified and being examined in that area. That is of cultural significance to the Fond du Lac community. And I see you nodding, and I'll take that I'm not off. If you think I am off, you can come up and tell me. People will tell me that, and that's okay. I know I'm not the smartest guy in the world, and I don't pretend to be, and I'll get it wrong, and my apologies for offending anybody if I do get it wrong. But I'm looking at that as a significant cultural site. Not any less, Spirit Lake is not cultural, but a lot of cultural sites are being identified in and around where that dam is and where the sturgeon habitat is and where Jay Cook Park is. And so my question to you, I've looked at this analysis. I studied the impacts of those all representative areas that we studied in the original one, and I look at where Pokegama and Little Pokegama is, and I'm stretching my mind to try to think how on earth those are going to impact at least those three significant cultural sites. Am I missing something there? Because I'm looking where they're coming into the water, and I'm having a hard time seeing Little Pokegama or Pokegama affecting the Fond du Lac area, affecting that dam, and affecting that sturgeon habitat. Am I missing something?
Madam Chair, Commissioner Tuma, I do not think you're missing something.
So as I look at this, I'm feeling comfortable, okay, with where I'm at with assessing this, that all the sites likely will not impact Lake Superior in any significant fashion. This is the highest moving, fastest water in the area, that representative, I think, of this area. So I'm comfortable with, you know, where we're at as far as understanding this. I do have a question for Enbridge. I don't know if it's Ms. Rusman, or are you going to wake Mr. Swanson up back there or not? No, he's smiling at me.
Ms. Brusvin, Senate media asked if, and I forgot to ask you, Ms. Miltage, but when you come back up, could you also state your name again, please, for their record? Or recording, I should say, of that.
Thank you, Madam Chair. Christy Brusvin, representing Enbridge.
If you could get that appendix B up of those, Scott, those different sites that I asked to get clarified, I wanted that up. So, Ms. Brusvin, while he gets that up, you know, the question I have for you, and we'll get in a little more detail, but as you heard, I'm feeling comfortable with what I've read. I don't feel I need to supplement it by asking questions of anybody. I'm feeling comfortable, and I'm feeling comfortable that she has answered my questions. My question for you is, do you agree that you have enough here as far as an analysis to meet the legal requirements to move forward with this particular scope so that now I can make a hard look at the route and the CN?
Madam Chair, Commissioner Tuma, yes, we do.
And then as I looked at this site, the one that was selected, I went back to a document that we asked for in the original process, and this was really to deal with the question of, are we getting what a cost of a full bore release was? So it's really not meant for the scoping, it was meant for something else. It was meant for, is your parental guarantee, is the insurance, is that enough? But when I went and looked back at this, when I was reading back through it, all of a sudden these things jumped out at me, and I said, I wonder where Little Otter Creek sits here, okay? And that was my curiosity as I looked at the numbers, and as you can see, number 29, the last one, is Little Otter Creek. And I'm not very good at cutting across, but it looks like if it's not 4, it's definitely 5 on the list of most impactful cost-wise. When I look at this list, I don't see the Sandy River. I don't see any of those sinewy rivers, those winding rivers, making the top 30, okay, as far as their financial impact. You provided this document. It's in the record. I want to make sure I'm reading that correctly, that it looks like, from a truth test, whether this is impactful or not, it seems like the study we did as far as cost goes would seem to support that. Would you agree with that, Mrs.?
Madam Chair, Commissioner Tuma, yes, I think that this confirms that Little Otter Creek, from, again, a cost perspective, is among the highest potential impacted by an oil spill.
And it's helpful because we're going to have to take a hard look. There will be questions in my mind, and I want to get answered in my mind, the impact, because APR and APR 21 don't cross Little Otter Creek, okay? 22 does, the route that we selected. And so I want to make sure we're careful in our analysis, and we're doing it smartly, and we're taking that hard look. Now, the existing line 3 with the bad coating and the leaking problems does presently cross Little Otter Creek. Is that correct?
Madam Chair, Commissioner Tuma, that's correct.
That's all the questions I have.
Are there questions from commissioners for other parties at this time? No. Any further questions, or are commissioners comfortable moving into deliberations at this point?
I have a couple of questions for the company.
Okay. Commissioner Means.
Good morning.
Good morning.
You heard the concern with respect to the 13-minute response time that's was in the written comments, and I know you did file a response to that, but could you refresh the record with respect to the company's response to that issue?
Madam Chair, Commissioner Means, so the 13-minute response time that is used in the modeling signifies the 10-minute rule, which is shut down, plus 3 minutes for the drain down effect of a pipe. It is the way that EPA has directed the spill modeling worst case discharge to be done. It is also consistent with your final scoping decision document and the comments that led up to and including the analysis that went into those modeling assumptions.
And Ms. Brusvin, federal mandates require the company to have emergency response plans and to demonstrate emergency preparedness. Is that correct?
Madam Chair, Commissioner Means, that's correct.
And does the company conduct emergency drill exercises for hypothetical oil releases?
Madam Chair, Commissioner Means, it does.
Can you also discuss some of the assurances that the mitigation measures that I believe are covered in Chapter 10 would be implemented?
Yeah, Madam Chair and Commissioner Means, so Enbridge has safety as its very top priority. No oil spill is a good oil spill, and the company works diligently to protect all of its assets, including Line 3 and the Line 3 replacement. You will find in this record a discussion in Section 2 of Appendix V, the addendum to the AAR, that describes in detail, well, I guess in summary in Section 2, how the company would respond in each of the water types crossed at the Little Otter Creek crossing, so from a small water course to a larger water course, all the way through to a larger lake, and including submerged oil. You'll also find as appendixes to that Appendix V of the AAR addendum, the Inland Spill Tactics Guide and the Submerged Oil Plan Response Plan that are in this document. And I would also remind folks that the Field Emergency Response Plan, which is the comprehensive emergency response plan for this Superior region, is also contained in the record as Appendix B to the original Certificate of Need application. The company takes this very seriously and has put an enormous amount of resources into both making sure that we're prepared, but also that the Commission has transparency into that. Just one final note, I'd also point out that the figure that Commissioner Tuma had up before as well also included control points. There are 12 of them pre-identified in this area downstream of Little Otter Creek. There's a site-specific plan at each one of those control points, and the company already has plans in place on how to get both people and equipment and the best tactics to use at each one of those so that the company could stop oil before it gets to that next point. Those wouldn't be the exclusive places where the company would respond in the event of a spill, but they're already pre-planned, site-specific, and in place today.
And you were present on Friday to hear the oral comments from the public, and there were several members who raised a very real and important serious issue relative to adverse sociological impacts, and that would be the issue of violence against girls and women in the areas where a pipeline is being constructed. What is the company's response to those comments?
Madam Chair, Commissioner Means, that was a point of significant public comment, both during the proceeding that led up to this and, as you mentioned, continues to be a comment that we hear frequently. First, the men and women who are going to construct this line have the utmost integrity, and Enbridge holds them to the highest standards. While we understand the larger and broader issue, which is serious and needs to be addressed, we do believe that it's important to distinguish activities and efforts to prevent those kinds of activities from the men and women who will be constructing this pipeline. But the Commission also took this concern very seriously and has required the company to put into place a human trafficking prevention plan. And in the course of the time since that requirement was originally put into place, the company has worked with existing groups that are already focused in that area and are leveraging their expertise, their networks, and are adding resources to that to help try to combat that very important issue.
Thank you, Counsel.
On the issue of the second revised EIS, are commissioners comfortable moving into deliberations at this point? Again, the question before the Commission at this point is whether the Commission should approve the second revised EIS and determine it adequate. I will begin by saying that I myself found the analysis sufficient to meet the adequacy standard under Minnesota Rule 4100.2800 subpart 4. And some of the main points of my review of adequacy were discussed here today, but they include that the selection and modeling of Little Otter Creek was done using similar considerations to other representative sites used in the EIS. The analysis includes the potential impacts to the St. Louis River and estuary, Spirit Lake, and Lake Superior. Chapter 5 includes impacts a spill would have on the natural and atmospheric environment, and impact on human environment, including cultural and economic values. The response time for a full-bore spill leak scenario are included in Chapter 3, and the modeling related to seasonal variations in river flow velocity, habitat data, and temperature and wind speed variations. So I will make a motion to find that the December 9th, 2009 second revised final EIS is adequate, and I'm open to hearing discussion on that motion. Commissioner Sugar.
Thank you, Madam Chair. Respectfully, I disagree. The Court of Appeals did remand this back to us with specific guidance. Part of that guidance was affirmation of a number of points of the prior FEIS, but they remanded it back to us specifically to address environmental impacts identified in scoping. Importantly, our rules that guide us today require that the data and analysis shall be commensurate with the importance of the impact and the relevance of the information to a reasoned choice among alternatives. It's back before us because the impacts to the Lake Superior watershed are critically important. I disagree that this second revised environmental impact statement is adequate. I believe the record and the law does not support the conclusion that the single site selected adequately represents the Lake Superior watershed. I also believe that the evidence and record does not support that the second revised EIS adequately assess the potential consequences of a spill in the Lake Superior watershed. And third, I believe the second revised EIS fails to accurately characterize the current scientific understanding as it relates to the impacts of spills in the Lake Superior watershed of climate change. We're required under MEPA to follow the guidance which is outlined in the first section of MEPA, that Minnesota's declared environmental policy is to create and maintain conditions under which human beings and nature can exist in productive harmony. This FEIS in this revision does not yet do that, in my viewpoint. And for these reasons, I believe the second revised EIS is not adequate, and I will not support the motion before us.
Commissioner Means.
I'll make a few statements because, as one of the parties stated, I was not a participant or decision maker in the last several years in this docket. The FEIS enables the Commission to make an informed and appropriate decision on the proposed project in order to minimize environmental issues through planned environmental and social management action. Technical, sociological, and cultural contexts and considerations rightly influence the FEIS outcome and effectiveness. This is a combined FEIS for both the Certificate of Need and route permit proceedings. I took a hard and full look at the FEIS found adequate by the Commission by order that was issued on May 1st, 2018. I would underscore that the Court of Appeals identified one issue of that FEIS for review, the failure to consider the impact of an oil spill in Lake Superior's watershed. On this narrow issue, after examining the extensive FEIS and the additional material and analysis, and considering the written comments of the parties and the public, and the oral comments Friday, in my opinion, the second revised FEIS provides the information necessary to assist the Commission in considering potentially significant adverse effects of an oil spill into the Lake Superior watershed, and therefore is adequate as that term is defined. I don't know where my colleagues are other than Commissioner Tuma. I don't know where Commissioner Tuma is on this issue, but I made this decision after applying the rules and the statutes to the facts contained in this record based mainly on the following reasons. First, as I stated, I did take a hard look at the FEIS. Adequacy is determined, as the chair stated, and in my opinion, there is sufficient evaluation and consideration of all the elements of the rule, including that the FEIS analyzed potential climate change impacts from the project. The FEIS analyzed potential impacts on historic and cultural resources, and the analysis of alternatives was exhaustive and thorough and objective. The Court of Appeals concluded that the Commission adequately analyzed the potential impacts to greenhouse gas emissions, potential impacts on historic and cultural resources, and the relative impacts of alternative routes and cumulative potential effects. The Court of Appeals upheld the Commission's May 18, 2000 order on adequacy relative to these topics, and after examining the full record, I agree. Secondly, again, the limited question today is whether the second revised FEIS addressed the one deficiency identified by the Court of Appeals. And I believe the answer is yes, again, for a few key reasons. The additional analysis contained in Chapter 10 evaluated and compared potentially significant adverse impacts and consequences generated by an oil spill in Lake Superior's watershed. Little Otter Creek was chosen as the representative site for this analysis. There is a rational basis for the selection as it is located within the Lake Superior watershed, and there is supporting information that this is the location where a hypothetical oil spill would most likely reach Lake Superior. This representative site for potential oil spill followed the same procedure and analysis as the initial 7 sites that were previously deemed adequate by the Commission and affirmed by the Court of Appeals. I am further persuaded by the logic of using a representative site with the characteristics and relevant properties as detailed, as opposed to a site-specific approach. It is not reasonable or beneficial or required by rule to model spills at every potential location. Additionally, Chapter 2 provides detailed supporting information with respect to the applicant's emergency response plan. The project is included in the Superior Response Zone and includes important information for applicants' response in the event of an emergency, including notification and spill response procedures. Moreover, Chapter 10 addresses about applicants' plan for spill prevention and response and answers the question, what will the company do if an oil release occurs to mitigate environmental impacts, minimize the spread, and what will the company do to clean up and restore damaged land, shorelines, and property affected? The revised FEIS is an analytical document. Of course, there is subjective interpretation on the predicted impacts and the methods that should be used to predict those impacts. However, as I determined from the reasoning and the instructions provided by the Court of Appeals, the revised FEIS addressed the deficiency identified, and I will support Chair's motion.
Thank you, Commissioner Tuma.
Madam Chair, that was very eloquently said. I don't think I really had to add much other than that. To me, the critical question really does come down what the rule states at 4410, where we are to identify and address the potential significant issues raised in scoping. That's what the court pointed out. I think this document now does that, and it's helpful to understand that so we can make a hard look at the different questions of route and CN. And when I look at all the options that were laid out, I think Little Otter Creek is the one that informs me the most to make some of those hard look decisions that I need to make with regards to Fond du Lac, with regards to the St. Louis River and its significant flow speed there's none of the other ones that I really could look at of the other representative sites than this one, because it's so unique compared to the others. So it really almost needed to be examined, and it's been very helpful for me as I started to now use that information to take a hard look at the route and at the CN. And so I think this was a good process. It was done well by the department, and I think I will support your motion, obviously.
All those in favor of my motion to find the December 9th, 2019 second revised final EIS adequate, please say aye.
Aye.
Aye. Opposed?
Aye.
The motion prevails. The commission is now going to be in recess for a lunch period. We will resume in the next round, just so everyone is aware. We will again hear opening comments on the certificate of need for approximately 5 minutes from each party, and then have debate and review that question. So we will be in recess now until approximately 10 after 12.